What about behaviors? Are our 504 students protected by extra due process or procedures like our IEP students? Hi, I'm John Comegno from the Comegno Law Group. Today in this segment, we're going to talk about disciplinary considerations with regard to 504. Specifically, are our 504 students eligible for additional protection? May we hold them accountable to our general education codes of conduct? Do we need to provide additional supports? Are there hurdles? Are there barriers? Are there extra considerations in how we mete out discipline or impose sanction for misconduct amongst 504 students? To answer this question, we need to consider contextually what 504 is. IEP, IDEA, as we've discussed in other segments, expands the right of the eligible student. The IEP student is eligible for additional protection instructionally. They have additional process requirements and rights, and they're eligible for manifestation determination hearings. There are limits practically imposed when we consider how we can discipline the classified, identified, or exceptional student. What about 504? What is 504? Well, as we know, 504 is very simply a prohibition against disability-based discrimination. Nowhere in 504 do we see the words manifestation determination. Nowhere in 504 do we see any specific direction that the 504 committee consider the impact of disability when considering discipline. Nowhere does the law tell us that we need to analytically or objectively, scientifically review whether or not misconduct, whether or not violations of the code of conduct may be implicated, may be manifestation, may be symptoms of the physical or mental impairment for which we found 504 eligibility. So we could say no, right? Then there is no added protection. There is no added process. There are no limits on our right to discipline. Seems to make sense, doesn't it? Unfortunately, it's not that easy. Unfortunately, frankly, those of you who serve as disciplinarian, those of you who have 504 administrator responsibility, actually have to be extra careful about our 504 students because the law protects against exclusion on the basis of disability. The law says practically, and the law's basic direction is that no otherwise qualified individual with a disability on the basis of that disability, on the basis of that physical or mental impairment, may be excluded, denied benefits, or treated differently. Excluded. So the law may not say and doesn't say that we've got to provide a manifestation determination or otherwise consider the discipline in relation to the disability, but it's saying to you, don't exclude on the basis of disability. Let me put that differently. The student with the oppositional defiant disorder, the student with the anxiety disorder, the student with the mental health issue and symptomatology which interferes with his compliance to the code of conduct, his compliance to teacher direction, his compliance to you, direction of the disciplinarian. That may equal symptoms of the disability. If we then suspend, if we then expel, if we then segregate as sanction, are we not violating the tenets of Section 504? We very well may. That's why your job is even harder than your special education peers. Our special education peers implement a manifestation determination, and we look very objectively, very analytically. It's very simple, if you will, to tie together. We need to have a similar focus. We can recognize that public education is a civil right and you are the state, and that's the hook. We are en loco parentis. You have disciplinary authority. But as the state, as protected by Section 504, we may not take away that civil right. We may not exclude or treat differently on the basis of that disability, which means, and this should be the overhanging principle when we talk about discipline and 504, we can't discipline symptoms. We can't discipline the manifestation then of that physical or mental impairment. General education students are entitled to due process. They're entitled to notice of a charge against them, and they're entitled to hearing. A hearing is very simply an opportunity to confront the charge, to be heard, to have consideration of their side of the story. The due process for the IDEA student, for the student protected by the IEP, is expanded through what we refer to as a manifestation determination meeting or hearing. The manifestation determination, the MD, if you will, looks at the relationship between the recognized disability and the misconduct. What I suggest to you by way of practice is that we don't necessarily always have to provide an MD, but we need to be mindful of manifestation of physical or mental impairment. We need to be mindful of symptoms. We need to be mindful of the impact of the disability for which we found 504 eligibility as it relates to the code of conduct, particularly for those students who are receiving accommodations that address compliance with the code of conduct. Is a behavioral intervention plan in place? Is a behavioral management plan in place? Has a behaviorist provided support? Has a teacher, through good old-fashioned differentiated instruction, addressed a student's inability to attend or focus, or incentivize behavior or compliance with a code of conduct? If so, that student's disciplinary issues, behavioral issues, the emotional manifestation, if you will, of the difficulty is on your radar. You're on notice. If we then take disciplinary action as to those symptoms, there's an argument that we're violating that student's 504 rights. Practically, what do we do? Some very practical suggestions. Those of you that have building level 504 responsibility who are not disciplinarian need to make sure that you're speaking with disciplinarian when we talk about discipline of the 504 student. Those of you who wear multiple hats, congratulations. I know many of you do wear those multiple hats. You need to wear both of those hats when considering potential discipline of the 504 student. That's speaking very generally. We may also consider the provision of manifestation determination for our 504 students. To do that, we need to understand what the manifestation determination is, and we need to understand what the questions are. There are essentially two questions. And there are two questions that work to protect against discrimination in discipline with regard to student misconduct in the 504 student. We're taking, and be mindful of this, we're taking concepts from IDEA and applying it to 504. That's not required under the law, but by way of best practice may serve a prophylactic and proactive role in ensuring that we're not violating civil rights of the 504 student. What are the questions? Two questions. The first question, number one, was the misconduct caused by, or did it have a direct and substantial relationship to the disability? Billy ADHD, who is off task and distracting his peers. Does that ADHD cause the misconduct, the failure to follow direction, the failure to comply with the code of conduct or not? If so, we can conclude that we should not be disciplining that behavior. Number one, causal relationship. Was the conduct caused by, or did it have a direct and substantial relationship? The facts could be different. Billy ADHD brings in an illegal substance, or brings in a weapon, or cheats on an exam. Those acts of misconduct, are they directly tied to the mental health diagnosis? I don't know. You're the practitioner. You're the expert in that regard. But that's the relationship that we're looking at in considering the first prong of the manifestation determination process. Number one, if the answer is yes, stop. Deal with that issue therapeutically. Deal with that issue by looking at the accommodations that we have provided in the 504. Are we implementing them consistently? If we're not, we need to. If we need to retool the accommodations that we're providing in the 504, then we ought to. We ought to get back to the table. If there's no relation, we can go on to the next question. So again, first question is causal relationship. Because of the physical or mental impairment, misconduct happened. Direct symptom. Number two looks to our actions. Did the student engage in misconduct because of our failure to implement the 504 plan? The question under IDEA focuses on IEP. That's not the issue here, obviously. The issue here is, did the student engage in misconduct because of our failure to implement the 504? The 504 provides testing accommodation. It provides use of laptop. It provides other assistive devices. And the student gets into a fight in the lunch line. We hadn't provided the testing accommodation. Do we think there's a causal relationship? Probably not. Student gets into a fight in the lunch line, and the student has anxiety, and the student has received additional counseling and social group, lunch bunch, and it turns out that he has not been reporting, we have not been sending notes, we have not been providing the service. Is there a causal relationship now? Again, that's a question for you, the experts, to determine. It's certainly a lot closer. If we conclude that there's a real impact because of our failure to implement accommodation or failure to implement consistently, we should not be disciplining. That type of discipline, that type of consequence or sanction may constitute disability-based discrimination because we may be failing to accommodate the difficulty, thus not providing access or penalizing the student. So who makes these kinds of decisions? If we elect to provide manifestation determination, since it's an IDEA principle, I suggest by way of best practice, it ought to similarly be administered, held, considered, implemented by our 504 committee. Let's have those same decision makers around the table with expertise that know the physical or mental impairment, know the diagnosis, know the issues, know the data, and are familiar with the data for which we've already found eligibility to apply that data to the manifestation determination. The more comprehensive our analysis, the more specific the data that we're relying upon, the more reliable, the more valid our determination will be. If we're going to provide MD, let's make sure we do it consistently. In other segments, we've talked about consistency in criteria. We've talked about consistency in data collection. Let's remember here, we need to be consistent in our approach with discipline. If Elementary 1 does not consider manifestation determination, but Elementary 2 does, and Elementary 1 student is suspended and challenges the fact that we've got an inconsistent approach, how do you expect to be successful? The same with vertical consistency. What are we doing at the middle school level? What are we doing at the high school level? Let's be consistent. Let's also be consistent if we're going to be employing manifestation determination. Let's be consistent with what the questions are, the kind of data we plug in, and the timelines that we're ascribing to that process. These procedures should be in writing. These procedures, you should be training your staff to employ and understand consistently. The takeaway, folks, in summation, IDEA changes, expands disciplinary protections and limits. 504 doesn't. 504 more nebulously says you can't discriminate on the basis of disability. You can't exclude on the basis of disability. The simple overarching principle is you can't discipline symptoms. Take that into consideration when we're considering discipline in an eligible student. I'm John Comegno. Thank you for tuning in. Be careful out there.